My name is Tim Monsees. I'm the senior and founding partner, but around here technically a shareholder of the Monsees and Mayer law firm. We've been in operation for 23 years, and what we do primarily, almost exclusively, is something related to plaintiff's personal injury, meaning we represent the party that's been injured or wronged in any kind of an event. Whether it's a car wreck or whether it's somebody who's been a victim of sexual abuse, we represent the party that has been the injured party, not the person who's defending the claim. And I want to talk to you a few minutes about mediation. What mediation is basically kind of a stylized or formalized settlement negotiation. Any settlement is a compromise, and its very essence of mediation means is that we both need to move towards what is our best case scenario versus what may be the defense best case scenario. And a mediation employs an impartial mediator, somebody who sits in the middle and basically plays the devil's advocate with both sides, trying to persuade them to find middle ground and settle the case. It is not binding. Ultimately, in a mediation, you as the client have the decision. It's yours to make. It may be influenced by obviously what we as your attorneys may influence you to do. It may be influenced by what the mediator may recommend, but the mediator has no power to resolve the case. At the conclusion of mediations, mediators frequently will make a recommendation of where that person believes the case may settle, but ultimately it's still in your hands as the client. So how does this all unfold? Usually the mediator first meets with the plaintiff. In this case, that would be us. That would be the party who's been injured or aggrieved by some wrongful conduct by the defendant. It's usually necessary for us to make the first what's called a demand or an opening offer at what we think the case ought to settle. That's usually at a much higher figure than what we might ultimately take, and then that figure is taken into the other room by the mediator and discussed with the defendant. They may or may not make a responding offer, and many times that responding offer could be considered nearly insulting. For instance, you may think that the case ought to be settled for $1 million. The other side may make an opening offer of $25,000, even though they may fully intend to get to a very high figure that would warrant settling the case. The key to any mediation is two ingredients. One, patience. If they are still in the room offering money, that means that the prospects of settlement are still out there. And even if you don't settle the case today, you've closed the gap. The playing field for what we might take in settlement, what they might offer in settlement, is narrowed from what may be a huge gap to a somewhat narrower gap. The other essence of any mediation or any settlement is compromise. We are not going to be able to settle the case in most instances for the best case scenario. Neither is the defendant going to settle the case for what they think is their best case scenario. They may think they're going to win. They may think they're going to win 3 out of 4 times. We may feel differently, but that influences how they offer money. You might have, for instance, $1 million worth of injuries, but if you're only going to win 1 out of 4 times, the settlement value of that case is not likely $1 million. So the bottom line is stay patient, stay open-minded, and compromise. You may not settle the case today, but the chances are good to excellent that you're in a better position at the end of mediation than you were at the beginning.